My name's Andrew Litchfield. I'm a partner in Gowling's dispute resolution group, and I do a lot of regulatory litigation involving quite a bit of environmental work. This is the fourth series, I think, in some webinars we've been holding over the summer with an environmental law and sustainability theme. And you'll have seen from the invitation, of course, that today we're focused on climate change litigation. Just to set the scene a little bit as to why we thought this was an appropriate topic, we've obviously seen gradually, but with increasing pace over the years, a much greater awareness of environmental matters, much greater demand for change coming through from the global population, much greater awareness of the risks and the dangers and the speed with which the climate is changing. Certainly in the UK, for example, we've had increasing numbers of demonstrations, increasingly popular demonstrations as well, and demands for change and demands for action, which even the politicians are starting to listen to and starting to take heed of. And that's feeding through into law and into legal requirements. Of course, the Paris Agreement of 2015 was a big moment. Lots of, over on this side of the Atlantic, lots of action from the EU as well as to in relation to climate change. And of course, in the UK, the UK government's commitment to net zero by 2050. And those things start to feed through into government policy and into local government policy. And then, of course, private companies start to take heed as well, and gradually and with increasing pace, things change. So I'm delighted today to be joined by three colleagues. Ben Stansfield is a partner in our real estate team. He's head of our UK litigation team, and I'm going to be talking to Ben and asking Ben in particular about how climate change is being used to influence or attack even government policy, and then the same question in relation to specific projects. Elsie Blackshaw-Crosby is an associate in our dispute resolution group with a special interest in environmental law. And I'm going to talk to Elsie about climate change in relation to companies, especially their reporting obligations and how those may be used or how those may be influenced in future litigation. And then finally, Liane Langstaff is an associate in our Toronto office, specialising in environmental law and environmental litigation, and I'm going to ask Liane some questions about the North American perspective and how things are seen over there and what the particular influences are over there. So the plan is for me to chat and to talk to everybody for about 45 minutes, and then we'll leave some time for questions at the end before we finish at around about past the hour. If you do have questions, please can I encourage you to put them in the Q&A box, which you'll find at the bottom of the screen. Could I also encourage you to put your name against any questions that you have, just in case if we don't get time to pick them up and answer them, we can contact you afterwards with some thoughts and some comments. And we'll come back to you later. So, Ben, let's start with you. We've seen some high-profile cases, I think, in the English courts where government policy, in particular in relation to infrastructure projects, has been challenged. What can you tell us about the recent events?
Yeah, you're right. In the last 6 to 12 months, we've seen a real flurry, and I think in the autumn we're going to see quite a few more cases. And these are judicial review challenges to government policy. So using climate change as the primary ground of argument. So a couple of cases to mention. First being Plan B, which is the Heathrow case. So by way of background, in 2015, the Paris Agreement was concluded following COP21, which is the UN International Climate Conference. That agreement set out to strengthen government action to reduce CO2 emissions, limited average temperature increases against pre-industrial levels to sort of 1.5 to 2 degrees. The UK ratified that agreement in December 2016, and then 18 months later, it designated the airport's national policy statement. And that policy statement recommended a third runway at Heathrow Airport, and by then Heathrow was well on the way to doing its, putting its application together. Unfortunately, the airport's national policy statement didn't mention Paris once. Just absolutely no reference, didn't factor in its obligations. So a claim for judicial review against the NPS was brought, High Court rejected it, but in February this year, the Court of Appeal sided with the claimants and said, yeah, it was legally fatal that the government's airport policy didn't mention Paris at all. So it declared the policy void and told the government, go away and reformulate your airports policy, but this time take account of Paris and net zero and your climate obligations. Heathrow's appealed to the Supreme Court and it's been given leave to appeal. So that's going to have a 2-day hearing on the 7th and 8th of October, so in just a few weeks' time. So watch this space. And remember, Heathrow hasn't even submitted its application for consent yet. This is all just policy-based stuff. So I think the key takeaway from the Heathrow case for now is that the Paris Agreement commitments, which are now effectively net zero, must be taken into account explicitly in all government policy. Now, that then led to another JR application. So following Plan B, 3 people got together. So Dale Vince, who's the founder of Ecotricity, the Good Law Project, and George Monbiot, a well-known environmental campaigner, came together and said to the Department for Energy and Industrial Strategy, you need to look again at your energy national policy statement. It's nearly 9 years old. It was adopted back in the days of 80% targets. There's essentially a chapter on fossil fuel developments. It doesn't mention solar once. It mentions wind 298 times. Doesn't even say anything about solar. Doesn't talk about electricity storage. This was adopted when Chris Huhne, remember him, the Lib Dem Secretary of State, was in the coalition government, so quite some time ago. Bit of law, I'm afraid. Section 6 of the Planning Act, 2008, says Secretary of State must review national policy statements whenever the Secretary of State thinks it's appropriate to do so. So if there's a significant change in circumstance, if there's a change that wasn't anticipated when the policy was made, or if there's a potential for a material difference in policy. So the claimant said, right, we'll write to the Secretary of State, please review it on the back of the Plan B case. Bayes declined to review it. They said, well, we've been thinking about it for a while, we just haven't got around to doing it. So a JR challenge was brought, and that's going to be heard in the 9th of November. Key takeaway from that, I think we have to see what happens in the Supreme Court. There's logic in what the claimants are saying. You know, there is something new to be considered here, but equally Bayes has got discretion, and it's obviously thought about it. My hunch is the government are not philosophically opposed to a review. It just probably wants to get Heathrow out of the way. There's Brexit, there's COVID. A full-scale review of energy policy is quite meaty right now, particularly if last week Hitachi pulled out of new nuclear in Wales. There is another case in relation to highways JR, but it's along the same sort of principle. So there's essentially 3 cases that this autumn will look at government policy.
Sounds like a pretty interesting few weeks to come on that score. Okay, so those challenges impact developers, but they're aimed at policy rather than specific projects. Has it all been policy-related JRs, or have we got claimants challenging specific projects on climate change grounds?
Yeah, well, we've had a number of project challenges, and you know, in recent months they've started to argue on climate change grounds too. So a couple to mention here. We've had the Chris Packham HS2 case, so the high-speed rail between London Euston and initially Birmingham. In March this year, Chris Packham, who's for our North American guest, he's a British naturalist, a TV presenter, an all-round good guy. He sought to challenge the Secretary of State for Transport, who took a decision following an internal review to proceed with the project. Chris Packham sought an interim injunction to protect 6 ancient woodlands. And actually, this was one of the first hearings we had in the pandemic. A number of grounds were argued, all environmental, a couple of climate change grounds in there as well. High Court wasn't persuaded, so he went to the Court of Appeal and said, can we have a hearing, an urgent hearing to talk about this? That was in July. And he essentially argued, look, the government failed to take account of greenhouse gas emissions and global temperature rises, in light of its obligations under Paris and the Climate Change Act. Court of Appeal rejected that, which is quite different to how it took matters on policy. It said, look, the government was at liberty to select the issues on which it was advised by that review. It wasn't constrained by policy or Climate Change Act. And actually, the government was fully aware of its Paris Agreement responsibilities, and it had taken those into account. So the case failed. Another one we had recently was Drax and Climate Earth. So in 2018, Drax, big power developer in the north of England, applied for a consent for 2 gas-fired power station generators. Secretary of State granted consent October last year, despite his inspectors recommending refusal. Climate Earth, some really prominent environmental campaign lawyers, they sought judicial review of that decision, including greenhouse gas and net zero arguments, and they all failed, surprisingly. So the judge said, need for the project was established in policy, and this was almost a merits type claim. Greenhouse gases emissions were relevant, but not necessarily inconsistent with policy. And he said, in any event, net zero is not incompatible with a policy statement. There are different pathways to securing the result, and it's quite open to the Secretary of State to think about other mechanisms by which carbon can be reduced, so carbon capture and storage or EU ETS. So again, I think the takeaway from those cases is the government is the courts are pretty unwilling to knock out consent for individual projects. There is a further case, Millstone, which I'll just very talk about. This was an energy from waste plant in North London, granted consent in 2017. A couple of years later, we had net zero. One of the local residents sought to get the Secretary of State to revoke the DCO, arguing change of circumstance, net zero, all this kind of stuff. Secretary of State said, no, I'm not going to do that. Went to the High Court, and the court said, no, look, this is just way too late in the day, government discretion, all that kind of stuff. So I think on that one, I think the court is not going to look at old consents. It seems unwilling to look at recent consents, and it's focusing on policy at the moment.
Yeah, so well, I mean, we'll have this conversation in a few weeks' time when those other cases are known about. But it seems like a greater willingness from the courts to get involved in policy as opposed to upsetting specific projects. Is that fair?
I think that's exactly right, Andrew. Yeah.
Okay. Let me turn to Elsie. Elsie, claims that sort of government and policy level that Ben was talking about. What about claims being brought directly against companies in relation to perhaps their reporting obligations on climate change? Just give us the background first.
Sorry, I've got to turn my video on. Thank you, Andrew. Pardon?
We can see you now. Go ahead.
Good, excellent. Yeah, so there are absolutely climate change litigation risks that are facing individual companies at the moment, arising from disclosures that they make in their annual reports and or their failures to adequately mitigate against climate change risks they're facing. I thought I might start initially by explaining the 3 types of climate change risk which companies need to take into account. And these are risks that have been identified by commentators, and in particular by Mark Carney in a speech he gave in 2015. So the first of these are physical risks, and these are risks arising from the direct impacts of climate change. So the negative impact of climate change on the value of a company's assets, for example. Risks that climate or weather-related events such as floods, storms, or wildfires may damage a company's physical assets or disrupt trade. That's one category of risk that companies may be facing from climate change. The second category of risk is transition risk. And these are financial risks faced by companies as a result of the process of adjustment towards a lower carbon economy. So, for example, this would encompass the financial impact on the company of any sudden or disorderly changes in government policy or regulation. It would encompass any changes as a result of, any risk as a result of changes to technology, or increased physical risks that could prompt a reassessment of the value of a large range of assets. And the third category of risk is liability risk. And this is the risk of future claims being brought against companies by parties who have suffered direct loss or damage from the effects of climate change and are seeking compensation from those that they hold responsible. I thought I might talk through these risks by looking at 3 case studies. from other jurisdictions where shareholders have brought claims against companies on the basis that they have failed to take adequate actions to mitigate both physical and transition risks, and or that they failed to disclose them to shareholders and prospective shareholders. And I understand that Liane is going to touch on briefly litigation in the US, which has been linked to liability risk.
Okay, so what have you been observing in other jurisdictions so far?
Yeah, so other jurisdictions seem to be further ahead than the UK in a lot of this litigation. The US is particularly far ahead, and Liane will go into various cases that are happening there. But I wanted to touch on one series of cases that's happening in the US being brought against Exxon. The claims have also been brought against the chairman, CEO, and directors. And the claims are shareholder claims. They're seeking damage for loss in value of their investments in Exxon. And their claims are based on material misrepresentations and breaches of fiduciary duty. So by way of background, the claim is made on the basis that Exxon made in its reports, annual accounts, and other public reports materially false and misleading statements about physical and transitional risks affecting or likely to affect the company. In broad terms, the public statement said that the company would face little material transitional risk from climate change and that the value of its assets would not be impacted. The claim also alleges that the company provided false and misleading assurances regarding those risks. And it alleges that in those same documents, the company failed to disclose material adverse climate-related facts about the company's business operations and its prospects. It is also claimed that the company employed internal practices that were inconsistent with the representations it made in its public statements. In particular, the company is alleged to have been applying a much lower proxy cost of greenhouse gases in their profit and loss calculations than it had been claiming in its external reports and publications. When the published proxy cost was actually applied internally, it resulted in enormous write-downs and profit readjustments. In terms of status of this case, it remains undecided, still going through the courts, and it's at various different stages because there's lots of different claims being brought against groups of shareholders in different courts. But it's clear that if the court doesn't find in favour of the claimants, it may well be on very claim-specific factors, which suggests that there were clear instances of deceit by the company and its directors, rather than just a claim based on general reporting. However, I think that the claim does show how shareholders are grappling with the risk posed to their investments by climate change, and how they're relying on public statements made by companies in relation to those risks in order to take action against companies and its directors where they consider that those risks have been misstated and they may have been misled in investing in those companies. And the second claim is a bit closer to home for those of us in Europe. It's a claim that was brought in Poland against a power company called Enea, and this one also relates to transition risk. So the claim was brought in 2019 by the environmental NGO Client Earth, who Ben has already mentioned and is very active in general in climate change litigation. Client Earth became a shareholder of the power company, and with the benefit of that position, it brought shareholder proceedings against the company, alleging that the company and its directors had failed to consider the material economic transition risks of its project to build a new coal-fired power plant costing 1.2 billion euros. In particular, the claim pointed to evidence from economic analysts, rating agencies, and energy industry experts that said that the project was likely to become unprofitable in the future due to the decarbonisation of the economy. In the end, the court didn't actually need to determine the climate risk claim, as they found that the company resolutions authorising constructions were invalid under Polish company law, and the construction was therefore unable to proceed without further compliant resolutions. However, Client Earth has put the directors on notice that should the company decide in the future to proceed with the construction of the power plant, it would bring claims for breach of directors' duties based on their failure to consider the material economic transition risks posed by the construction, and on the basis that any such decision would be harmful both to the company and its shareholders. So why is this relevant to us in the UK or in the US? Well, at least in the UK, similar directors' duties exist, and companies, I think that companies need to bear in mind the risk of litigation where significant strategic decisions are seen to have been made without taking into account transition risk. Another interesting aspect of this case, and one also to bear in mind, are the tactics used by Client Earth. They became a shareholder of a target company with arguably the single aim of bringing litigation to stop activities which they see as being harmful to the environment. So there's one last case study that I was going to look at briefly, and this is a claim against a utility in California. A utility company in California. So this company had been found to have caused some of the 2017 wildfires as a result of its operations. By way of background, as I say, this was linked to the wildfires in California in 2017, which were said to have spread quite so rapidly because of the very dry conditions, which would link to drought caused by climate change. Federal investigations after the fire found that this utilities company's failure adequately to maintain its power lines and to keep them clear of trees and clear of faults caused those power lines to start what were initially small fires, which then resulted in numerous uncontrollable and devastating wildfires because of the drought. The company has subsequently filed for bankruptcy as a result of the liability claims made against it in relation to the fires. And following that filing, shareholders have brought a claim against the company's directors, its officers, and also the banks involved in underwriting its corporate debts, claiming that they made misleading statements about the risks, regulatory compliance, and investments in power line safety, which led shareholders to have a false impression of the company's business, operations, and financial success. And I wanted to highlight this case today as an example of a claim where the company's activities were neither directly linked to climate change, nor was it part of a carbon-heavy industry, and yet it's been forced to file for bankruptcy because of damage, i.e. physical risk, caused by its activity, which happened as a result of the physical impact of climate change. The risk of damage was not reflected in its reports, and there was insufficient actions taken by the company to mitigate those risks. And this has allowed shareholders to bring claims for misrepresentation.
Okay, so is there any sign of anything similar or anything that is coming down the tracks in the UK?
Well, as I said at the beginning, the UK is definitely a little bit further behind on this type of climate risk litigation. We've not seen any similar cases to date. But saying that, we don't think it will be long before we do start seeing cases brought in the UK in relation to climate change disclosures in company reports and or mitigation taken by the company in relation to climate risks. We think that such claims may be brought either by regulators for failure to comply with relevant regulatory reporting regimes, or by shareholders claiming misrepresentation and or breach of fiduciary duties. I therefore thought it would be helpful briefly to comment on the status of reporting on climate change risk in the UK. So in our experience, reporting and disclosures on these issues are typically quite high level, and environmental disclosures often focus on greenhouse gas emissions and backward-looking statements about the impact of the company's operation on the environment, rather than forward-looking statements about risk going forward. As you'll all be aware, there are various reporting requirements under the Companies Act which require narrative reporting of the principal risks and uncertainties facing the company. And there are also financial reporting requirements under Part 15 of the Companies Act, requiring UK companies to prepare accounts that provide a true and fair view of the company's financial position. And given that climate change is a very real risk faced by companies, both narrative and financial reports should reflect the physical transition and liability climate change risks, if applicable, that a company is facing. Admittedly, the legislative and regulatory regimes applicable in the UK don't yet explicitly require this level of detail, but there's undoubtedly mounting pressure for them to do so, and it would be fair to say that the regulatory and legislative frameworks are in flux on these issues. and there are signs that the UK companies will soon be required to report in line with the very prescriptive framework supported by the Task Force on Climate-related Disclosures. In the meantime, however, it's important to consider whether your company's public reports accurately reflect the climate risks faced by the company, and whether there might be any litigation risk associated with those disclosures. Companies and their boards of directors need to become aware that investors will be scrutinising these disclosures and potentially placing reliance on them, which, if it turns out to be unfounded, may well lead to the type of litigation that we've been seeing in other jurisdictions.
So there's a distinction between climate change groups joining or becoming shareholders for the sole purpose of bringing a claim on the one hand, and other investors, other shareholders who've made a genuine investment, but who may be worrying that they've suffered a loss as a result of the misstatements that may have been made.
Yeah, absolutely. There's definitely that distinction, and you know, there's the activist element of organisations like Client Earth, who are undoubtedly using every avenue that's available to them to bring action against companies that they see to either be directly involved in climate or in activities that are damaging the climate, or supporting activities. So, for example, through financing of companies, and they're also raising a lot of challenges against those sorts of companies as well.
Okay, so in its infancy over here in the UK, by the sound of it, but I suspect, as with everything, you're way ahead of us in North America. So Liane, what can you tell us about what's going on over there?
Thanks, Andrew. So North America has been experiencing some of the same trends that Ben and Elsie were telling us about. But there is a bit of a different regulatory context that changes the types of transition and litigation risks that we see. And so that's what I'd like to take you through kind of as the backdrop. But in Canada, at least, there is a lot of consensus about the need to do something about climate change. Canada is a signatory to the Paris Accord. It declared a climate emergency in 2019, shortly after the UK did. Canada has also adopted net zero commitments by 2050. So in that respect, we're very similar. But what's a little bit different is in Canada and indeed in the US, it's a bit disjointed about how we are going to curb emissions. And so although there's some form of carbon pricing across Canada, it varies depending on the jurisdiction. And so what we see is, for instance, in British Columbia, they have a carbon tax. In Quebec, they have a cap and trade system that links with the Western Climate Initiative so that they can trade emissions permits with US states like California. And then we have as well federal backstop legislation that tries to promote at least the same level of stringency. And so it's called the Greenhouse Gas Pollution Pricing Act, and it imposes a fuel charge or sets up this system for large industrial emitters. And it only applies, though, in those provinces and territories that don't have their own carbon pricing scheme that meet the kind of base level of federal stringency. And the only difficulty is that this is very contentious and it's subject to litigation because of our federal system. And it's particularly timely to be talking about this because just yesterday, our highest level of court, the Supreme Court of Canada, heard a constitutional challenge to the Greenhouse Gas Pollution Pricing Act. And so what had happened was Ontario, Saskatchewan, and Alberta all challenged the constitutionality of that act. I act for one of the interveners, the Canadian Public Health Association, along with my Gowling WOD colleagues, Jennifer King and Mike Finley. And to give you a flavor of just, and full disclosure of what our client's position was, because the Canadian Public Health Association views climate change as a public health threat, it supported the Greenhouse Gas Pollution Pricing Act and supported really some form of government action at all levels. So we will have to see what happens with it because the success in the lower courts was divided. The Courts of Appeal of Ontario and Saskatchewan deemed the act constitutional, but Alberta deemed it unconstitutional. So now that all the submissions are in, we'll see what ends up happening at the Supreme Court. But I think the most important thing to take away from this landscape is that there is tension in North America, and it emphasizes the transition risk that Elsie was talking about. So because there are these disagreements about what's the best way to curb emissions, it can make it difficult for businesses to know what to do because the regulations are in flux. Certain regulations might be struck down with these lawsuits, or when political regimes change, new, more stringent regulations, or maybe even less stringent regulations might come into play, causing the costs of transitioning to these different regimes. And it also poses a related litigation and reputation risk, because it might be more difficult for a company to rely on regulations or to point to them when they're constantly changing, especially when different stakeholders have different views about what they think is appropriate in the circumstances. So regardless of what we see in terms of specific regulations, we often tell the companies we work with that they should continue to track and make efforts to mitigate their greenhouse gases wherever possible, so that they're ready no matter what happens in terms of the regulatory environment.
Okay, so just picking up on that last point you just made there, actually, what do you think in-house counsel or boards need to know about the general picture of North American lawsuits?
So I think in-house counsel and boards of directors should also be cognizant that they're going to have to comply with these regulations, but that they could too be the subject of lawsuits like Elsie and Ben were telling us about. I'm going to talk a little bit about two different types of lawsuits. The first being tort claims against large carbon emitters, and the second being securities law cases, similar to what Elsie took us through. And again, we look to the US. It tends to be a more litigious society than Canada, so they're at the leading edge of what's happening on the climate litigation front as well. And in particular, there have been lawsuits by civil society groups and even municipalities claiming that large corporations caused or contributed to adverse climate impacts. And for this, I'll take us to New York City. So New York City launched a lawsuit against major carbon emitters for the costs to protect its citizens from climate change. And so if you think of things like flooding risk, stormwater management, sea level rise, all of that has a hefty infrastructure price tag. And so they were looking for damages to deal with some of these costs. In that case, it was dismissed in July of 2018, but I went to an appeal in November of 2019. That's when it was argued. We're still waiting on the result of that, but win or lose, it sends ripples, and it sends ripples into Canada. And so the cities of Toronto and Victoria in BC also considered whether or not they should launch similar lawsuits, and had that studied by their municipal staff. But I will say that on this branch of kind of tort claims, it's difficult. There's lots of challenges about whether those claims will ultimately be successful. They're often challenged due to causation issues. It's just so difficult to prove that one company or even a handful of companies are the direct cause of the climate change harms that an entity is experiencing. And so that seems to be one of the major problems with them. And for that reason, a more immediate concern, especially for publicly traded companies, are the securities law cases that Elsie took us through. And so it can be shareholders bringing these cases. But the other thing that we'll likely see more and more in the future is securities regulators taking on these types of cases to ensure compliance with disclosure obligations. And again, to illustrate this risk, we go to New York. The Attorney General of the state of New York brought a case against ExxonMobil for allegedly misleading shareholders about the cost of climate change. And that decision came out in December of 2019, so also relatively recent. And in the end, the court ruled in favor of Exxon. So you might be thinking, well, okay, one of these first cases, it doesn't even lead anywhere. But I would caution that the facts matter. So in that case, New York State took issue with certain sustainability reports that Exxon had released between 2013 and 2017. And Exxon then adduced evidence from leading investors that they hadn't really made their decisions based on those reports. And so they didn't even have to go into really what the report said. There were no material misstatements that could mislead a reasonable investor. They were looking elsewhere. But I would caution that that was 2013 to 2017, and reasonable investor expectations may be changing. Elsie mentioned, well, Mark Carney has been telling us about these risks since at least 2015, but I think the voices in the investment community have been amplifying. They're reading the results coming from the Intergovernmental Panel on Climate Change, and we're seeing people like Larry Fink, the BlackRock CEO, coming out and making statements about climate risk and its importance. In terms of Canada, when we haven't seen these types of securities lawsuits yet, but securities regulators are setting the stage so that companies better understand their obligations when it comes to climate change. And so last year, the Canadian Securities Administrators issued a specific notice about reporting on climate risks. It was still more of an encouragement and I guess a note about how to better go about this, as opposed to thou shalt do this. But it did encourage moving beyond vague disclosures, and instead it recommended relevant, clear, and understandable entity level disclosure. And this goes off of what Elsie was talking about as well. It's not enough to have a one-off statement that climate change is a risk, or backward-looking, this was our impact on climate change. Forward-looking, what are the risks in the categories of your litigation risk, your transition risk, and your physical risks? And then what are you doing to manage those risks? So that's one thing that we're seeing in the disclosure context. And as a final note, I note that the Canadian Climate Law Initiative, which is an organization that I work with, they recently commissioned a legal opinion. It was released in July, and it concluded that corporate board members and officers are legally obligated to address climate change risks and opportunities. And again, this will vary. The exact risks and opportunities will vary based on your business, but through the corporate duty of care, boards have responsibilities to be informed about the risks of climate change and to be satisfied that the risks that are most material to their business are being adequately managed. And if they don't do so, they will open themselves up to risks of climate lawsuits in the future.
So that sounds like a very clear shot across the bows of anybody on those boards, that they need to be thinking about that very seriously. Ben mentioned the impact of climate change on specific projects over here in the UK. What's happening with regard to climate change and project approvals in North America?
I would agree with Ben that climate change concerns have and will arise even more in major project approvals in Canada. What we've saw in the past is, under the Canadian Environmental Assessment Act, you could always consider climate change in terms of when you were gathering information to help tribunals make decisions about whether or not to approve major projects. And there was also judicial reviews in the same way that Ben was talking about, especially when it came to oil sands projects and pipeline projects is where it most frequently came up. But now it's changing to be really any type of project should be taking this into account. And the reason for this is legislative change. And so last year, we repealed our former Canadian Environmental Assessment Act, put into force a new act, the Canadian Impact Assessment Act. And the act makes climate change front and center. And some of this is a bit of lip service. You'll see it in the preamble to the act, and it says we are trying to meet our Paris Accord commitments and things of that nature. But it also shows up in the meat. So when you talk about whether or not a new project will be approved, it has to be in the public interest. And the public interest is kind of this broad, amorphous topic. It can mean a wide variety of things. But what the statute tells us it does include, certainly, is the extent to which a designated project either hinders or contributes to the Government of Canada's international climate commitments and obligations, like Paris. And so the types of cases that Ben spoke about, they've already occurred, and I think they'll continue to occur in the future in Canada.
Okay, thank you very much. We thought that it would be particularly helpful for everybody if we also pulled together on an attempt to put onto one slide the some practical hints and tips and things that you should be doing and shouldn't be doing. And hopefully, as if by magic, that slide will appear on our screens at any second now. Here we go. And then I think that Ben and Elsie, and here it comes, Liane, are going to take 3 each. So I'm going to hand back over to Ben just to pick up the first 3.
Yeah. Okay. So I'm going to deal with, and we haven't put these in any particular order. So audit your consent application. So obviously that was something I was talking about earlier. These applications take months and years to put together. You can often get blind to the gaps, to the holes. It's really helpful to do a pre-submission audit, legal audit of your application. Make sure that the obvious GAR grounds have been taken out. Environmental impact assessment remains, and I think will for a couple of years before climate change takes over. I think EIA challenges will remain the primary means for knocking out your projects. And that's not, you might not be building power stations, you might be building a new headquarters, a new factory. Get those reviewed. Make sure they comply with legal requirements, and all your notices, all that kind of stuff are taken care of. Next one below that, understand the stakeholder mood where law and policy lags behind. Now, this is also relevant to what I was talking about in terms of policy, which hasn't kept up with the stakeholder mood. And I think when you're putting together your applications for your project, you need to think about what the law requires you, but also what your stakeholders are expecting. So you might need to go beyond legal requirements in order to reduce a JR challenge, or you might need to anticipate that, look, this is all going in one direction. The policy might not be as climate change friendly as the campaigners would like, but maybe you just need to take that extra step now and do it voluntarily. So just sort of understand what your stakeholders are thinking. And that links with my final point on engage with your stakeholders. So speak to your employees, speak to your customers, speak to your investors, speak to climate groups or local opposition groups who are against your project, or don't like the products you're manufacturing. If you engage with them openly and transparently, you'll understand what they think you're doing well, so do more of that, but also where they think you can improve, what you can do better. No one's perfect on climate. I've got a diesel 4x4, which I don't like admitting to as an environmental lawyer, but I don't drive it much, so it's okay. I don't want to replace it with something new. But understand where your weaknesses are, because that's going to be really good stuff for your Section 172 corporate reports, where you talk about what you're doing with the community and what have you. And I think you'll be really encouraged by some of the findings. I think I'm now handing over to Elsie.
Yeah, thank you, Ben. I'm going to deal with 3 of these practical steps that are on your slide as well. And the first of them that I am going to deal with is the disclosure needs to be accurate and consistent. So this comes back to what I was talking about the possibility of litigation being brought against disclosures which are found to be inaccurate or to misrepresent the reality of climate risk faced by companies. So I've got sort of 4 bullets that I would suggest that you consider when making any disclosures. First of all is that you need to really clearly describe any assumptions or methodology that you're following. So that can be referred back to when people are considering your disclosures. You also need to think about forward-looking statements particularly carefully, and who knows what will happen in the future. We've all got that uncertainty, and so you should make forward-looking statements appropriately caveated. My third sort of thought on the accuracy and consistency of disclosures is that you should make sure that you test the quantity, quality, and comparability of the information that's being disclosed. So you're not saying one thing in one part of the report and one thing in the other part of the report. And outside of sort of your formal reports and accounts, ensure that all company communications are consistent and none of them extend beyond what the company is actually able to achieve and what it's actually doing. And the second aspect that I was going to look at in terms of practical steps was the tile of embed climate change into risk management. So I think things are definitely changing internally at many companies, but climate change can still be seen sometimes as a slightly siloed issue, relevant to your ESG reporting, but not necessarily being considered elsewhere and in all aspects of your business. So we recommend that companies adopt strategies to manage the risk that climate change poses, but also ensure that climate change risk becomes an embedded part of risk management and all strategic decision-making processes. Also make sure that any decisions or discussions that board of directors are having, or any advice that you get given, it's properly documented and appropriately documented, so that you can point to advice that you may have had, or decisions that you may have made and the basis of those decisions. And finally, just make sure that it's cross-functional teams are involved in the consideration of climate change, so you can make sure that you're accurately looking at the impact of climate change across all business aspects. And the third tile I'm going to deal with today is expect disclosure requirements to change. So as I've said, there are currently very broad requirements under the Companies Act in the UK, but we're definitely seeing a change and a move towards the TCFD framework for reporting, which is far more detailed. And the government, in its 2019 green financing strategy document, said that it was expecting at least all public companies to be reporting in line with that framework by 2022. And there is clear indication from a number of different regulators that they will also be expecting companies that fall underneath their regulatory function to be reporting in line with that. So we would just recommend that you are alert to future reporting and disclosure requirements, and you're taking steps now to understand the upcoming scope and implement any necessary changes in advance of any deadlines that come about, because it can take an awful lot of work behind the scenes to be able to report accurately in line with any new reporting requirements. And you may, in doing so, wish to consider getting involved in policy consultations or with your trade association in order to shape the new regulations that may impact your sector, and in that way you can then have a say.
Okay, I think that just leaves three tiles. Liane, are you going to pick those up?
I can pick those up. So the last ones that I would talk about are to conduct risk assessments. So it's part of that embedding climate change into risk management, but specifically take the time to conduct a risk assessment to identify the risks to your business, more specifically from climate change. And like Elsie said, I also agree with having a cross-functional team ensure that they cover all aspects of the business, including supply chain, and that the board should receive adequate training to ensure that it understands these risks. You wouldn't expect the board to know this right off the bat. And so they need to have the training, but also have access to the experts who can give them the advice they need to make considered decisions. I would also say disclose trends and uncertainties. So be transparent and disclose the trends and uncertainties expected to have a material impact on your business. And then third, it's rapid response. So implement mechanisms to respond rapidly to changes in the company's risk profile as a result of climate change. Things are constantly changing. Last year, we wouldn't have thought that pandemic risk was going to be material to your business necessarily. Maybe the scientists did, but we as lay people didn't know. So be attuned to those things as they change, because climate change, it is very difficult because it's a risk multiplier. It takes the risks that we already are seeing in the world and makes them that much more serious. And that's why it's important for boards of directors to be alive to these issues.
Thank you, everybody. Can I, Liane, while you've got the microphone, before you switch yourself back on again, because I just want to pick up this question which has come in on the Q&A from Wayne Bolton, and you touched on it a little bit there when you were talking about one of those practical steps. So the question you've probably seen is, climate change, although a certainty, is highly dynamic and complex scientific phenomenon. What level of scientific depth should boards and directors be expected to have? And you mentioned training and external advice, but this is an endless. You could go on forever and ever, and they've got plenty of other things to be doing. So at what point, how expert do they need to become in order to demonstrate they've met their fiduciary duties?
I would say it's not, the standard is never perfection. I think Ben had said that it is a learning process. And I think that you shouldn't expect your board members to be scientists. And it would be the same level of diligence that would be required if you have no financial or accounting background, and yet you're on the board in a strategic role or a human resources role, some other aspect and expertise is what you bring. You still need to have a working knowledge of the financial statements and to be able to understand what the experts are telling you from the company and in order to make considered decisions. And I think that would be the same standard when it comes to climate change. You're not expected to be able to read the IPCC report and understand everything that is being told to you, or the specifics, or to anticipate yourself what the specifics would be for your business. But you would have to be willing to receive a small degree of training and then listen to the experts, either internal to the company or external, in order to make a considered decision. I also think it goes back to, Elsie mentioned documentation, and I think documentation of the steps you've taken can also show due diligence in this respect.
Yeah, and I suppose it depends to a huge degree on what the nature of your business is. If you're a carbon heavy business, you're going to need to be much more greatly informed than somebody with a less of an impact on the environment, I would say.
Although that might be changing, yeah. Given Elsie's California electricity example.
Yeah. Ben, you've talked about JR as a remedy, and there's a sort of theme about. I mean, personally, I love the idea of thinking about the lawyer within the New York municipality who decided that there may be a claim that could be brought for the extra cost that they're having to incur in protecting from flood damage. So JR as a remedy, okay, but often it just quashes the original decision and makes the decision maker just go around again, and they can go around again, and okay, it's delay and it's cost and it's inconvenience and it's adverse PR, but you can make the decision again, and this time nod to whatever you failed to nod to before, and away you go. So isn't that the case? It does not really get you anywhere in the end.
I mean, you're absolutely right. The decision gets ripped up. The decision maker is told to do it again and correct the procedural error. In this case, it will be, they could start with their airports policy and say, notwithstanding the Paris Agreement, which we are fully aware of and take note of, we think we should have another third runway. So yes, they could. I think it goes back to this sort of mood music, which we've talked about, that I think climate change is so ingrained in everyone's mind now, and I think COVID's probably really helped us understand that a little bit. But I think because it's becoming great, I think it's a pretty bold move, I think, for the government to reformulate policy and totally ignore this. I mean, slightly difficult, isn't it, with Runway 3 because it's quite political with Boris and so forth. But and obviously the need case for a third runway is tricky now because we're not flying, we're not traveling, we're doing things by Zoom much more. But Heathrow is saying, look, in 10, 15 years' time, we will be traveling again. We will need Heathrow runway 3. So I think my hunch is that, the policy will still require or will still enable the runway to be constructed, but there will be a much greater discussion as to how the government will still meet its climate targets, notwithstanding, the extra aviation and what have you. So I think they'll go to town on the new policy, but yes, I suspect they'll come up with the same conclusion.
And so, what about other novel arguments that might be that the people like the clever lawyer in New York came up with in relation to flood damage? So what else is coming down the track? There's a question that someone's raised here about human rights legislation or wider integration of climate change considerations into rationality challenges. What else have we seen around the world for novel arguments that you could be deployed?
I can pick up on this one initially, Andrew, if you want. The human rights question is absolutely bang on. Like, there are quite a lot of instances now of claims being brought against governments based on sort of human rights issues. And actually, earlier this month, there was a case that was launched or issued by a group of young people in Portugal against, I think it was over 20 governments in the EU, who, and they're basing their claim, well, they brought it to the European Court of Human Rights and based it on they've based it on the European Convention of Human Rights on a number of different articles, including the right to life, and they're saying that the government's failures to sort of act in accordance with obligations to reduce carbon emissions is a breach of their right to life. So yeah, absolutely seeing different challenges. Yeah, and companies are being sort of focused on as well in sort of different ways. So there was a claim that I think was actually being heard and was heard yesterday by the court in Poland in relation to another power plant, coal power plant, and the company in, well, again, it was another Client Earth case where the Client Earth said that the environment was a common good, and I understand that under Polish law there's a requirement for the courts to protect common goods, and on that basis Client Earth challenged the ongoing use of these incredibly damaging coal power plants, and we saw the court order quite a novel remedy where they ordered the owner of the coal power plants to actually sit down at a table with Client Earth and discuss their concerns and come up with a solution, which it's not a remedy I've ever heard of, certainly not under English law, but it's showing that both the claimants and people who are concerned about the environment are sort of scratching their heads and coming up with every possible angle to bring claims, but the courts are also doing the same, and they're sort of having to take a practical approach because they don't necessarily have the tools and solutions in their sort of normal toolkit to answer the concerns.
I think that could be an interesting meeting, couldn't it? Be a fly on the wall between the enforced meeting between the coal-fired power station operator and the environmental activists.
Yeah, it'll be one I'll be watching and seeing what happens, certainly.
Yeah. Will that be an effective court remedy? I think we're very nearly out of time, but just let me pick up one more corporate governance question before we finish, which is, again, similar to the degree of expertise that we touched on before. This is a question about, again, the degree of knowledge I think that boards need to have. And so do we think that this is becoming so material and so important that it needs to be the topic of a specially constituted board committee? Liane, do you want to go on that one because it's related to what you said before? Sure.
I think there are board committees already for climate change, especially like you said, for companies that are very carbon intensive. If you are an oil company yourself, you probably are already doing this. They're ahead of us on this. You'll see it more and more that I think it would be useful to have a board committee. But to go to one of Elsie's points, it should be a cross-functional team, and you should have it come back to governance decisions of the entire board. So even if you have a breakaway committee, at the end of the day, all the board members are responsible for climate risk and mitigation, and so they need to be involved in that decision as well.
Okay, we're just over past, so our time is up. Can I just say thank you to everyone for joining and listening in, and for the questions that have come through. We haven't picked up them all, but the ones we haven't we'll answer separately. Thank you for your time. We will be doing more on this subject, I am sure, in the future. It's a very hot topic. There's an awful lot of, as you heard earlier, from the amount of cases that are coming through, the frequency, how recent all those challenges are, and the fact that many of them are still going through the courts as we speak. So there will be more to come on this topic, and one to follow with interest. So please watch out and for those, and we'll see you next time. Thank you very much.